to our conference room today. All right, it looks like we have everyone in from the waiting room, so I'm going to go ahead and get started. Good morning. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference for Phase 1A of the hearing on the pending petitions of Consolidated Irrigation District, Fresno Irrigation District, and Alta Irrigation District, and Semi-Tropic Improvement District of Semi-Tropic Water Storage District, to revoke or revise the declaration of fully appropriated stream systems with respect to the Kings River system, on a potential revocation of water right licenses 11517 and 11521, and on a proposed cease and desist order against the Kings River Water Association and its member units. This pre-hearing conference is being held in accordance with the hearing officer's ruling of February 19th, 2021, and subsequent rulings since that time, and the amended notice of public hearing and pre-hearing conference dated March 19th, 2021. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we'll post files of this recording and the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. And if you're experiencing technical difficulties today trying to communicate with us, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov. Assisting me today, as usual, are several staff from the Administrative Hearings Office: Nicole Mullen, Amy Blunk, Megan Nyes, and Kyle Wooldridge. Let's go ahead and move to appearances. We're rolling along since we've been together a number of times now. To do that, I'm going to identify each of the entities on our service list. And as I do, if you're representing that entity today, please unmute your microphone and state your name. First, Semi-Tropic Water Storage District.
Good morning, Ms. Kinsey. Kevin O'Brien for Semi-Tropic.
Good morning, Mr. O'Brien. Kings River Water Association.
Joe Hughes for the Kings River Water Association.
Good morning, Mr. Hughes.
And Leonard Hurst also here for Kings River.
Good morning. Alta, Consolidated, and Fresno Irrigation Districts.
Good morning, Nick Jacobs representing Alta Consolidated and Fresno Irrigation Districts.
Jeff Boswell representing Fresno Irrigation District.
Good morning.
Good morning, Lauren Lane, General Counsel for Alta Irrigation District and Consolidated Irrigation District.
Good morning. Tulare Lake Basin Water Storage District.
Good morning, Ms. Kinsey. Peter Keel, and I'm joined by co-counsel Aubrey Moritzen and Josh Fox.
Good morning. McMullen Area Groundwater Sustainability Agency.
Good morning, Ms. Kinsey. Robert Donlan for MAGSA. I'm joined by Sean DeGrady.
MAGSA, maybe I can use this. Good morning. I can't get Tulare Lake Basin Water Storage District. That acronym, it just doesn't roll off the tongue, so we'll work on what to call it. A Laguna Irrigation District et al.
Good morning, Jennifer Spalletta for Laguna Irrigation District et al.
Thank you. Good morning. People's Ditch Company and Last Chance Water Ditch Company.
Good morning, Ken Richardson for People's and Last Chance.
Good morning. And there you are. I was looking for your picture. Good morning. Terra Nova Ranch.
Good morning, Ms. Kinsey. Russell McLaughlin before Terra Nova Ranch.
Thank you. Good morning. And California Department of Fish and Wildlife.
Good morning, Kathleen Miller for CDFW.
Great, thank you. Is there anyone else who intends to participate today who I have not identified or who has not identified themselves? Wonderful. We're moving along. Okay. The purpose of this pre-hearing conference is to address procedural issues related to Phase 1A of this hearing And just as a matter of background, I wanted to make sure all of you are aware of the hearing officer's ruling that was issued yesterday, April 6th. That ruling grants Tulare Lake Basin and KRWA's motions to quash the subpoenas ducis tecum issued by Semitropic. The ruling also sets May 26th as the deadline for submittal of rebuttal exhibits, including written rebuttal testimony. And just of note, I also directed in each section when you're submitting that rebuttal testimony, please identify the particular evidence submitted by another party that the testimony is intended to rebut. I think that will help streamline things and make sure that rebuttal testimony is, in fact, rebuttal testimony. So I appreciate that. On the agenda for today, I have the following, and then we can add to that if others have topics. First, the general order of proceeding and witness testimony at the hearing. That would include time allowed for direct testimony based on the amended NOIs that we have received. And I'm going to go through those and make sure we received, I think we received everyone's, but we'll go through that. The presentation of witnesses and panels, I think that's a good idea to streamline cross-examination, and I want to talk about that a little more. And then also the time, briefly, we can touch on time for cross-examination. Second on my, I have all that as one agenda item. Second on my agenda, I have setting an additional day of hearing for the week of June 7th. I think realistically, if we're going to have rebuttal, we may need another day. I would like to say not, but we may. I'm not going to set the date today. I realize you'll need to talk to your witnesses and things, but I want to talk about that. Third on the agenda is any other issues. And then finally, fourth, setting our next pre-hearing conference. So I'm going to invite comments on each of those as we go through them, but I'll start with witness testimony. The AHO received amended NOIs, timely amended NOIs from the following parties indicating that they intend to present cases in chief. I have an NOI from Semitropic, KRWA, Alta Consolidated and Fresno Irrigation Districts, Tulare Lake Basin Water Storage District, what are we calling, MAGSA, McMullen Area GSA, and Terra Nova Ranch. And then the following parties indicated in amended NOIs that they intend to participate but not present a case in chief. And that's Peoples Ditch Company and Last Chance Water Ditch Company, Laguna Irrigation District, and CDFW. Are there any corrections to that? I'll pause there. Does that sound right? Our records are right. Great. So I thought I would talk first about the times on the NOIs that came in for summaries of written testimony, and then we'll move to witness panels, which is kind of a cross-examination topic. So I apologize, I have sort of a lot to say. So I apologize, you will all get a chance to chime in as appropriate. First of all, I appreciate that looks to me like all of you front-loaded your witness list for the case in chief. That is great. I asked you to do that, so that's good. I appreciate that. But also keeping in mind that the total amount of time requested for witness summaries of testimony was, I think, 13.5 hours when I added it all up. So we're going to cut that down quite a bit, and we'll figure out how to do that. I realize it's a maximum. I mean, I would imagine you came in and estimated your maximum. So inherently there's hopefully some room in there. But we have 3 days right now to hear from your witnesses. And really, I see the primary purpose of hearing as for cross-examination. That's why they're there. I'm going to be, you will all be submitting that written testimony in advance. I will be spending the month of May reading that written testimony of your witnesses, reading it carefully, reading it twice or 3 times if I need to. I also have assistance, technical assistance from Mr. Woldridge to help me understand the technical testimony. So I think in a little bit of a difference from maybe your standard board hearing where you have a board member hearing officer who I'd like to say are very good at reading all of the testimony, or at least the important parts. They have other obligations, but my job for the month of May is to read that testimony, and I will do it, and I will do it carefully. And I think I have pretty good reading comprehension. So I would like to suggest that I think in most instances, it might be perfectly appropriate for your witness to simply affirm their written testimony, because I will have read it. If I have questions, I won't hesitate to ask them. I intend to keep track of questions, especially on the more technical testimony where I'm sure I will have questions. If there are particular points that your witnesses want to emphasize, I can understand that. I don't see why that would take more than about 5 minutes. And then if they're particularly complex or technical portions of the testimony, that I can see also may merit some additional time to go through that, okay? But but I will, as I said, I'll be keeping notes when I go through the testimony. I will be asking questions. I will be active and participating to try to really understand the written testimony. But I will have read it in advance, so anything, in theory, anything your witness says in your case in chief, I will have already heard before. I also realize I saw on the witness list, I think there's at least one, what I would call an adverse witness. I saw Mr. Damon Hess is going to be called by, I believe it's the Kings River Irrigation Districts. And if there are other witnesses, so the time for that testimony I realize will be longer because I expect you won't have his written testimony in advance. I could be wrong, but so that's a little different. I realize that's an exception. And if there are other witnesses on your lists that are sort of generally in the camp of what we might call an adverse witness, and you may not have written testimony for them in advance, if you could please let me know today, it just will help in the planning. I would appreciate that. So my thought on this is that I'm not going to set strict time limits for cases in chief, because I think the problem with time limits is I think then there's a tendency to go right up to the maximum, unless you want me to set time limits, and then I can. But what I'd like to say is I will stop your witnesses if I need to during the hearing and move us along. If that testimony is not helpful for me to understand the testimony and really get to the issues that are in play for phase 1A, and if we're not on track to finish the hearing within the scheduled time. So that's what I'd like to do. If there are comments on that, I'm going to stop here. Are there any comments on what I've said so far or questions? Realizing we're going to talk about cross-examination in a minute. But are there any thoughts about, and panels for witnesses in a minute, but any other thoughts on direct testimony or time limits or moving through this more quickly?
Ms. Kinsey, Kevin O'Brien for Semi-Tropic. We certainly accept your direction as to these time limits. I think it would be helpful just in terms of preparing our witnesses to have a sense, and I'm thinking about our technical witnesses in particular, who will be getting into some fairly complicated hydrology. If you could give us maybe just a general sense of what you're thinking in terms of the sort of time allocation.
Okay, I can do that. I will take a look more carefully at the number of technical witnesses and I mean, what I was thinking, oh, excuse me, let me pull up. I have a nice Excel spreadsheet of all of our witnesses here. So I mean, I actually think I'll be Semi-Tropic. You have, I think, been fairly fair in your estimates, and including for the more technical. So I think I'll give more concrete direction, but I actually think yours is within range. I am aware of the fact that Semi-Tropic is generally, I think, positioned in this proceeding to be presenting a certain type of evidence, and then the other parties are presenting evidence that's, generally speaking, adverse. So there is some disparity in the amount of time that will be going forward. So I am generally going to allow Semi-Tropic the opportunity to explain your technical evidence, as with the other parties. But I would ask the other parties to coordinate with each other. You have a number of witnesses on technical issues that it's hard for me to tell just from the substance, but may overlap. So to the extent we can coordinate that and not go through the same information twice, that would be great. So thank you, Mr. O'Brien. I will put out an estimate, keeping in mind that we may move things along more quickly, or I may allow additional time if we're getting into substance that is really helpful and I want to hear from your witnesses more. And that goes for all of you.
Thank you.
Are there other comments on that? So I'll move along to panels of witnesses. I do think that's a good idea. And I think it was you, Mr. O'Brien, who brought this up the last pre-hearing conference. I think it's quite helpful for cross-examination to work in panels. It's more efficient and it moves us along more quickly. Looking through the list of topics, it seems like some of these topics can be grouped fairly obviously together, where your witnesses would go together. I'll leave that up to you. One thing of note, and I'll just mention it to think about. We'll come back to this, I think, after the written testimony is in, but I noticed there are a few topics here that I'm not convinced relate to the phase 1A or would really be helpful to get into in phase 1A. One I can call out is the background on Semi-Tropic and its project. I'm sure that's interesting. I'm not sure it's most appropriate for this phase of the proceeding. Again, I haven't seen the written testimony, so this is certainly not a ruling on the issue. I'm just flagging it. And then I think there was another witness by one of the other parties about Semi-Tropics grant application. Again, you know, I have not seen the testimony. I'm just not sure it's relevant here. So I'm asking all of you to be efficient in the testimony that you present and evidence that you present, because even if we shorten that case in chief direct testimony, we still have to go through cross, and I want to make sure we go through that efficiently. I think what I'd like to do is just go through all of you today, and maybe you can give me an estimate. I'm not going to hold you to it, but just let me know when you're looking at your witnesses, how many panels you're thinking. I'm thinking in most cases 2 would be about appropriate, but you may have an exception. And like I said, I'm asking you this on the fly, but if we can just go through, I'm pulling up my list of all of us today, and you can talk me through what you think would be appropriate for panels. I'll start with you, Mr. O'Brien, and we'll go from there.
Yeah, I think 2 panels is about right. I would think that Mr. Tagavi and Ms. Boisavain, who are our engineering witnesses, would be one panel. And then we can, I think, group the other witnesses in the other panel.
Great. And then Mr. Hughes.
The way that I'm looking at it, and again, looking at our notice of intent to appear, what jumps out at me is there's the technical and then other. And I think the other encompasses, I think there's a general theme there. And I think that that can be done in one panel for efficiency's sake. So I guess to summarize that, there would be the technical folks and then the other folks.
Great, thank you. And then Mr. Jacobs, you have the most here. So talk to me about what you think would be appropriate with this number of witnesses, please.
I think we could do the same kind of panel breakdown that Mr. Hughes described, or we could make it 3 panels. We could have a technical panel, we could have a Sustainable Groundwater Management Act panel, and we could have a Disadvantaged Community Impact panel. And somewhere we would work in there the issues related to the Semi-Tropic grant application that you referenced, which we will be brief on, but I do think is relevant.
And then Mr. Hess, I assume that would be, he would be sort of a separate from those.
Yeah, I think so.
Yeah, yeah. And am I correct that we are not expecting written testimony from him in advance?
No, I don't think we will. I'm still hoping, I have not yet seen the Enforcement Division's file that you requested.
Yeah.
So that should be informative.
Yeah. And then I guess we'll go to Tulare Lake, Mr. Keel.
Thank you. Our 2 witnesses are focused on surface water hydrology. And so we support the idea of having a technical panel. Maybe a suggestion is that we potentially have 2 technical panels on the Kings River user side, one focus on surface water and the other focus on groundwater. I think that'd be a little more logical division of experts.
So the idea would be that all of the Kings River, that would be Tulare Lake Basin, the irrigation districts and KRWA would put on witnesses together in one consolidated panel. Is that what you're thinking?
Potentially, I think that's something that we need to discuss, but I believe that TLB witnesses will complement the other units.
Okay, that would be great. I mean, if you can work that out and talk to each other, we can revisit this in another pre-hearing conference. We can talk about when that's an appropriate time, or we can communicate through written communication as appropriate to work that out. I think that would be helpful for all and make sense just in terms of grouping the information and my understanding of the issues. So I think that would be helpful if that may work. Otherwise, though, are you thinking that, Mr. Keel, that your 2 witnesses would be together in one panel?
Yes.
Thank you.
Thank you.
Mr. Donlin.
Yes, right now I think we're thinking that our 2 engineering consultants would be a single panel.
Mhm.
and Mr. Hurley, the general manager for MAGSA, would be separate, but it's possible that we could maybe roll all of our witnesses into a single panel for purposes of cross-examination.
Okay, see if that makes sense. And then last, I think it's Mr. McLaughlin.
We have no problem combining our two witnesses in this single panel.
Are there any objections to those proposals on the panels in terms of, I mean, I know we want it to make sense for cross, but does anyone have any concerns about that proposal and the way these are suggested? And I'll go in, so I'll keep moving on. I'm talking about time. Once again, I don't want to make a decision about time now. I will set, it sounds like it'd be helpful if I set time limits for cross-examination, but I think that makes more sense to do that after we see what the testimony is. So I think we'll revisit that later. But I did want to mention that I'm not planning to allow what I'd call friendly cross. So the way I envision this hearing going forward is that we'd hear from Semi-Tropic first and their case in chief, and then the other parties would have an opportunity to cross-examine those witnesses. And then we'd move on to probably, and you can tell me what order you'd like to go in, but maybe KRWA. But I'm expecting that cross will be conducted by Semi-Tropic and possibly CDFW, but I'm not anticipating, and you can correct me if I'm wrong, I'm not anticipating a lot of cross-examination by the other parties because generally your interests should be aligned at least on these issues. I realize there are differences and it's a large watershed, but at least on these issues. Does anyone want to comment on that part of this? Is that an accurate assumption about how cross-examination is going to go?
Ms. Kenzie, this is Robert Donlin.
Yes,
when
please.
will you decide the amount of time and the opportunity to cross-examine? Is that after the case in chief is submitted or after the direct testimony is submitted at the hearing?
I was thinking we would talk about it at we can decide when our next pre-hearing conference is, but at the pre-hearing conference that is immediately after the deadline for submitting written testimony, the May 2nd deadline. So I thought we would revisit that issue there, whether I decided at the pre-hearing conference or whether we, in a ruling shortly after, so that you know coming into the hearing how much time you have to cross-examine the different panels.
Thank you.
Does that make sense to you, or do you have another thought? I'm certainly open to structuring this differently.
No, it just wasn't clear to me when you described the sequencing earlier.
I'm making a note. Yes,
Ms. Kenzie, I think the way you laid it out makes sense. The only thing I would say is that the cross ought to be totally evident after the rebuttal testimony, I think, is presented. So I don't see a circumstance under which we would be cross-examining KRWA or any party really but Semi-Tropic. But I think wouldn't that be all clear after the rebuttal testimony is go forward?
After the rebuttal testimony is submitted, that would make sense. Yes, I think so. Yes.
So when you're talking about having another pre-hearing conference that comes immediately after submission of the direct testimony, we could probably make a call at that point, but I'm not sure. We still have a couple of weeks to submit the rebuttal.
Yes.
I don't think it's going to be an issue. I'm just.
Well, what would the part? Well, we can get to this later. But if you prefer for me to make a decision about it sooner, I can. And if it makes more sense to wait until after that rebuttal evidence is in, we can do that too. I just want you to have the information you need to plan your time efficiently.
Okay.
Thank you. So based on that, we're moving along quickly, and I'm going to get to other issues in case there's other issues, but I do want to talk about setting another day for hearing, mostly for rebuttal. What I envision is that we need another day for rebuttal. Once again, I appreciate that it looks like you really identified your witnesses up front and plan to submit written testimony in the case in chief. But there will be opportunity for rebuttal. I think we need another day, and I may identify 2 days just to hold them. The week of June 7th, I know that some of you have another trial coming up shortly after that, and that's challenging, but we'll try to move through this hearing as quickly as possible. I'm not going to ask today, certainly for you to commit to a day, but what I'd like to do is ask you to let me know what 2 additional days the week of June 7th you would prefer as hearing days for us to hold. And if you anticipate that you have particular or potential rebuttal witnesses that truly are not available on any days, please let me know that as well. I will plan to be somewhat flexible. I realize we're identifying these dates later than the other hearing days. So if we need to move witness testimony around, we can try to do that to accommodate, as long as we can do that in an orderly way. So if you can email the AHO at the AHO email inbox, you all know it, and CC the service list by next week, April 14th, and let me know your preferences on 2 additional days the week of June 7th. I would appreciate it. And then I will set those days as a hold as soon as possible, so that we all know and we can reserve those and use them if we need them. Are there any comments on that issue? Mr. Keel, I saw you go off mute.
Thank you, Ms. Kinsey. I am a little concerned about the relatively short period of time between submission of rebuttal testimony and the start of the hearing. I think providing through the 25th or 6th, whichever, is a reasonable deadline, but I am a little concerned about evaluating rebuttal testimony with hearing. I think having hearing on the week of the 7th might be a little fast. So I express that concern. I don't have a solution.
Yep. I understand. I hear your concern. I think we're working with what may be deadlines by other parties for the following weeks of June. Now, if you can come up with an agreement agreeing on days later in June, I'd be certainly willing to hear that. And so I can ask you to work together, but I'm aware of another trial that's proceeding, and I think we'd like to get this done. So if there's other days in June that the parties can agree on, I am certainly open to that. Otherwise, I'd like to move forward and get this phase 1A done. But thank you, Mr. Keel. Your concern is noted.
Ms. Kinsey, Kevin O'Brien, just so you're aware, the other trial that I think I mentioned that Mr. McLaughlin and I are involved in has been kicked back to August, so that's less of a concern now.
Okay, well then, thank you. I think then it makes sense to give us a little time in between for rebuttal. So maybe we should change that approach slightly. Let me do this on the fly. And thank you, Mr. O'Brien, for that. So let's look at I will hear proposals. Let's keep that April 14th deadline for you to submit proposals, but let's push it back. Let's look at the week of June 14th. Well, how about this? You can make your proposals for any time in June. I will tell you, I personally plan to be out of town possibly the 23rd through the 28th of June. So those are off the table. But other than that, if you have suggestions and preferred days, please let me know, or days when your witnesses are definitely not available. And but I'm looking at probably the week of June 14th, I think makes sense. That will give us an additional week as opposed to doing it the week of June 7th. Does that make sense?
Just to confirm, we're talking about pushing back the start of the hearing.
No, I'm sorry. Let me clarify. I'm talking about pushing back the days when we would hear rebuttal testimony. So the hearing is going to go June 2nd, 3rd, and 4th. That's when we'll hear cases in chief. And then we can set additional days for rebuttal, ideally the week of June 14th. And that will give us additional time between the deadline for submission of rebuttal testimony and the hearing days when we will hear summaries of that testimony and cross-examination of those rebuttal witnesses. Thank you for asking for the clarification. Other comments or points of clarification? Are there any other procedural issues we'd like to talk about today other than setting up another pre-hearing conference?
Ms. Kinsey, I did want to talk about post-hearing briefs versus closing argument. My experience in hearings of this type is that briefing is generally more helpful to the hearing officer, and I'd prefer to make that decision sooner rather than later so that we can be prepared to submit briefs shortly after the hearing concludes. But certainly others might have other thoughts on that.
I'll just say I'm in favor of written post-hearing briefs as opposed to, I mean, you can make a short summary, but I would like to see written post-hearing briefs. Mr. Hughes, I see you may have a comment.
I was going to agree with that approach.
I agree.
Great. Let's do that. We'll set page limits and a deadline for that probably at the hearing. But I will give an appropriate amount of time after the hearing to submit those, after the close of rebuttal, to submit those. Other procedural issues or comments? So I'd like to schedule another pre-hearing conference. I think it would be helpful after the deadline for filing written exhibits on May 2nd or 3rd. Excuse me, let me look at my calendar. May 3rd. I thought the following week would make sense to give us an opportunity to digest the amount of testimony, not read through it all, but just understand what is there. So I was looking at May 11th or 12th. Are there any objections or concerns or suggestions for a different day?
Either of those work for me.
Great, thank you.
And I'm assuming 9 a.m. usual time.
Yes, yes. Any others with concerns? I'm looking at May 11th. We're narrowing down to May 11th. All right, let's reconvene May 11th at 9 a.m. Between then and now, I expect to hear from you about dates for 2 rebuttal hearing days. Ideally, identify 2 the week of June 14th, but if you have other preferences in June, please let me know. And then you will hear from me about time limits, excuse me, time limits for direct testimony. Are there any other outstanding items on our list, on our to-do list?
Ms. Kinsey, one question or request, please. We'll probably need to identify additional deadline for amended notice of intent for any additional rebuttal witnesses. So if you could advise us on when that might occur, or we could offer suggestions in the future. I don't have a specific suggestion right now.
Okay, that's helpful. I'm trying to think. Do we need that if we have an advanced deadline for the witness testimony? Is that helpful? Do we need a deadline to identify the rebuttal witnesses? Or is there not a preference? I can think about this more. Honestly, I hadn't thought about it, so it's a good point. All right, well, I'll think about it and see what makes sense, but it's a good point. I'll address whether or not we should have amended NOIs for rebuttal witnesses, and if so, what an appropriate deadline for that would be. Thank you. Anything else on our to-do list before we close for the day? All right, thank you. Thank you for joining me today. I think this was helpful. I'm glad it was quick. This pre-hearing conference is adjourned, and I'll see you all on May 11th, if not sooner. Thank you very much.
Thank you.
Thank you.
Thank you.